heard that a trust avoids probate, but how does it actually work? Today, I'm going to explain how a trust works in California and why it's one of the most effective tools for protecting your family. Have you been told that you need a trust, but no one has actually clearly explained to you why or how it works? A trust is one of the most powerful estate planning tools available to California families, but it's also one of the most misunderstood. Most people think it's only for the wealthy or that it automatically solves every problem. Well, like most things, the truth is more nuanced. What you will learn in this video is what a trust actually is and how it functions, the key roles involved in a trust, which is the settlor, trustee, and beneficiaries, how a trust avoids probate in California, and what happens to your assets while you are alive. Oh, and last, of course, how a properly designed estate plan ensures your wishes are carried out by the people who you have chosen and that they have the tools they need to do their job without involving the time and expense of court intervention. If you want clarity about whether a trust makes sense for your family and how to use it correctly, this video will give you the foundation you need. So, what is a trust really? A trust is essentially a legal contract where you transfer your assets into the title of that contract or trust, which you continue to control during your lifetime as long as you have mental capacity. You are typically the settlor, the creator of the trust. You are also the initial trustee or manager of the trust, and you're also the beneficiary during your lifetime. We're talking about a revocable trust. This means that you maintain total control during your lifetime and can change or revoke the trust and your assets at any time. But the trust does become irrevocable upon your permanent mental incapacity or your death. This ensures that no one gets to make any changes to the trust except for you. The key roles in a trust. First, there's the settlor. That's the person who creates the trust and funds the trust with their assets. Funding the trust simply means the act of replacing your name as an individual on the trust and changing that to the name of the trust with you as trustee. You still maintain control and nothing changes about the way you bank or pay taxes. The trustee is the person responsible for managing the trust assets according to the written instructions within the trust. This is usually you as long as you have mental capacity. The successor trustee is the person who you have named to step in if you become incapacitated or pass away, and their job is to carry out the trust. The beneficiaries are the people who receive the assets as gifts from the trust according to how you have dictated it. To clarify a common misconception, the trustee does not own the assets personally. The trust does. They manage the assets in a fiduciary capacity, but there is nuance to this. If the settlor is the same person as the trustee, that's you do still own the assets. But once a successor trustee steps in, then that trust has inevitably become irrevocable, so that successor trustee cannot make any changes, and their job is to manage the assets on your behalf for the benefit of the beneficiaries. How does a trust avoid probate in California? Well, first, probate is the court-supervised process to ensure your assets are transferred to your legal heirs in a legal manner. Unfortunately, our court system is very antiquated and under-resourced, and if anything has to go through the court process, it's going to be time-consuming and expensive. Not to mention, everything becomes subject to public information. Essentially, it's a lawsuit that someone files on your behalf against your estate to ensure creditors are paid and assets are transferred in a legal manner to your legal heirs. When assets are properly titled in the name of your trust, They are not subject to probate because these assets have that designation of being titled into the trust, which then gives your successor trustee the full authority to manage those assets. If the asset has not been properly funded or titled in the name of the trust, you must have court approval, usually through the probate process, for the trustee to have that authorization. The successor trustee can distribute assets privately and more efficiently because court involvement is not required. An important note, assets must be properly funded into the trust for this to work. Next, what happens when you're alive? Well, as long as you have mental capacity, you can still buy, sell, refinance, manage your property, do whatever you want with it. Your income and taxes remain the same, and the way you bank and file taxes remains the same. But if you become incapacitated or pass away, your successor trustee steps in without court involvement. This provides continuity and protection for your family. Next, how a comprehensive estate plan makes a trust effective. A trust is only one piece of a comprehensive plan. A well-created plan that is holistic and covers everything is coupled with your pour-over will, a power of attorney, and an advanced healthcare directive, along with properly aligned beneficiary designations on the accounts themselves. Regular updates ensure that the plan reflects life as it currently is. Life is going to change. There's going to be new assets, changes in family dynamics, and it is very important that your plan is updated to reflect these changes. The goal with a properly executed comprehensive estate plan is clarity, control, and protection. It's not just about paperwork. It's keeping your family out of conflict and out of court. It is extremely important that your estate plan is updated when life changes to ensure that the plan still works the way that you want it to be. If you're wondering whether a trust is right for your family, don't rely on assumptions or internet advice. Click the link below or comment to schedule your complimentary 15-minute consultation and learn how to create a comprehensive estate plan that protects your loved ones and your assets. You do need to be a California resident to sign up for an initial consultation. So don't leave your family navigating probate or confusion in a time of grief. Plan intentionally. Please follow us and subscribe to stay up to date on all things estate planning. Thanks for watching, and we hope to see you soon.